bills are still going to hit. Okay. All right. Um, Individuals who want to control the transition of their assets to the next generation. If you don't leave a will in place, then wherever you live, if I pass away and I don't have a will, the state of Virginia is going to decide how my assets are divided. Well, maybe that's not how I want my things to be transitioned. So what you have to do is you have to start as early as possible to make sure that a plan is in place, because I love the way Dr. Paz put it. Legacy planning is an act of love for your family. They are already going to be grieving. And so you don't want to put that burden on them. But then the other thing is that a lot of what we do, we want to be able to pass on the fruits of our labor to the next generation. But we know our kids, we know our family. There may be some that maybe we need to put some assets in trust and have a fiduciary or trustee dole out the assets over a period of time. Whereas, you may have a family member that you're okay with, just, hey, you can just have this asset and go for it. I trust that you will take care of it. But estate planning gives you the opportunity to be in control of how things are going to be passed on. And we've already talked about some of this. Why bother? You want to avoid having your assets divided based on state law. You want to avoid court intervention during a period of incapacitation. If I did not have a power of attorney in place, I would have to, apply to the court to be the conservator of my father's assets. That takes time, that takes money. We try to help folks avoid the probate process altogether and to minimize tax liabilities. Now, you'll recall in the beginning, I said that there are a couple of aspects to legacy planning in terms of your assets. You want to discuss things with your financial advisor. And then once you have a hold on how you want your assets to transition, then you come into the legal realm. And then we talk about how you use legal documents to accomplish what you and the financial advisor have discussed. You can select your own fiduciaries. Who do you want to be in charge of transitioning your wealth? And if you have minor children, or if you have parents that are aging, you may want to designate folks who could be guardians or conservators. Okay, for yourself and for minors or aging parents. Okay, how to start? Well, the first thing you want to do is you want to just consider your goals of, I have property in DC, I have property in Florida. What would I like to happen to that? Do I want to pass it on to my children? Or are they so entitled that, no, I want it to go to someone else? So you start thinking about those type of things. Typically what I will do is give a client a questionnaire, and it helps you to go through the process of just thinking, okay, what is it that I have? What assets do I have? And you also want to take inventory of your liabilities. You want to identify the folks that you want to bless as your beneficiaries, and you want to identify fiduciaries. For example, I would not necessarily designate my son as my financial power of attorney because he just loves to spend money. Now, I would designate my daughter because she's tight with the dollar, but I would not designate her as my medical power of attorney because Blair would probably say, I just pull the plug. But my son would probably say, no, give mom a chance. So, you want to take into consideration who you want to play what role. And then you want to gather all your important documents, your life insurance policies, information.
What is your problem? What is your problem that you are making this with my brother?
On retirement.
Tell me what is your problem?
Any information on retirement plans
and
research. You want to
I am talking to
research. You want to research your
financial
advisors.
I'm sorry, Tony. I'm sorry, Tony.
No
but
worries.
it appears we have a spammer.
Yeah, that's not spammer. I want to talk. Why you are doing this to my brother?
Okay.
Why are you doing this to my brother?
I need you to. I'm trying to remove him. I removed him, but he got back into the Zoom. So I'm going to
So Swords, yeah, if you
monitor.
can try, you can block him in your spam section. So we apologize.
We
No
This is what
worries. It's
apologize.
happens.
not, it's not on you. I tell you, this is the world we live in today, you know?
And so we can just take him out of, I think there's a permanent way to block him. If you just right click.
I tell you, you would think
Okay,
other people
yeah,
So
have better
this,
things to
I
do.
apologize, Tony. I just reported it. I'm not sure. I didn't see an option to block, but here he is again.
if we can, so I know Swords, if one of you can make me a co-host, we'll try to find that as well. We will not allow this to separate this program because it's much needed. So just go ahead and try to make me a co-host as well and see if we can try to figure this out while we're doing
Okay,
this.
I
Okay,
will
we can
do
talk
that right
normal.
now.
So everyone,
We
we do
can talk
apologize
normal
for
now.
this, but someone is trying to block our blessing today, but we're not gonna let it happen.
That's right.
Oh,
Okay.
gosh. I'm trying to find you, Nicole. My apologies to everyone. This is
We've never had this happen, but as we're doing this, we'll go ahead and do two things. So one, as they're trying to get the technology version of this, I'm Nicole Jordan. I'm the president of Washington DC Alumni Chapter. I am ecstatic to have all of you here today with us for this most important conversation, and we're going to let this conversation occur. And we will make sure that whoever that is who's trying to get in our meeting won't be in here. But as you already heard from everyone, it's very important for this to occur based on based on the fact that all of us really truly this is something that we need to take time and planning and not when there's an emergency. So I want to
Right.
thank all of our guests and all of those for coming. I think we may have had them blocked. Let's just go ahead and keep going. And if we need to, we will set up another meeting for those on here if needed to.
Okay.
All right. So
Thank
let's go ahead
you.
and keep going and let's see what's happening. Thank you.
Okay. Thank you. Okay. All right. So what are the basic estate planning documents? And again, we are going to talk about the last will and testament, the trust, but you also want to consider the durable power of attorney and an advanced medical directive. They all work together. The durable power of attorney is going to designate someone to assist you with financial matters, either during maybe you're temporarily incapacitated, or maybe you're just not available. You're working abroad for a year. The advanced medical directive, this is also an agent for you who in the medical realm, when you're unable to speak for yourself, you have a designated agent. And under both of these documents, your fiduciary or your agent has to follow whatever instructions that you indicate in those documents. So we're going to take a look at each one very quickly. Okay, the last will and testament is a legal document, and it will set out your instructions as to how you want your assets divided and distributed. Not just to people, you can leave, people actually name their pets in their wills. People actually can set aside at times trust funds to take care of pets, organizations, churches, and you select your beneficiaries. It's very important who you select as your fiduciary. In my situation, my father designated me as a fiduciary for his will. And even if you have a trust, it still doesn't negate the need for a will, because what happens is you can have a will and never put any assets into it. If you have a trust, it's just a piece of paper if you don't actually transfer certain assets into the trust. So even when folks have a trust, for example, we will also draft what we call a pour over will. And what that means is upon a person's transition, if there's any asset that they fail to pour into the trust, your pour over will basically says, hey, if there's anything in this estate, my intention is that all of those assets be transferred into the trust. Okay.
For a bit today, so yeah, I saw that on the
Is that a question?
Can everyone mute their phones? Actually, I'll go in and.
Oh, okay. I didn't know that was a question. Okay.
No.
If there is no will in place, like we discussed before, now you're talking about wherever you live, that jurisdiction's law will dictate how your assets are divided. Now, just to illustrate the difference, so here in Virginia, the husband and wife are married and they have minor children, and the husband passes away. Then all of his assets by law pass to his wife. Now, that same family sitting in Maryland, same circumstances with minor children, the wife gets only a percentage of his assets. The remaining percentage is set aside for the minor children. So you see that even from jurisdiction to jurisdiction, there are different laws governing the division and the distribution of assets upon someone's death. So you don't want to leave it in the hands of the Commonwealth of Virginia or the District of Columbia to determine where your assets are going to go. And, estate planning is not one of those sexy topics, but it's very necessary. I mean, we all buy car insurance, prayerfully, none of us will ever be in a car accident, but I guarantee you that we're all going to go away from here one day. So it is definitely worth the time and effort to, typically people want to think about these things when someone's near death. And we have actually gone to hospital beds and had people sign estate documents, but you don't want to be in that type of situation. So these are the type of things you want to think of now when it's not an emergency, when you do have a clear head. And we even tell folks, once you do an estate plan, every tax year, review your estate documents and consider, do you need to make changes? So don't think if you do your estate planning that you're locked in. You can always revise. Okay, so this is something I was just touching on. You draft a will today, you have some family members who show their tail and you're like, you know what? This is not going to happen. I need to change some things. That is no problem with that. A will can be revoked very easily. Now, back in the day, if someone wanted to change their will, they would draft what they call codicils. Well, with technology and computers and things now, we typically advise clients just shred the old will, and we're just going to have a whole new clean will so that there won't be any issues. I'm sure we're all familiar with those stories of someone contesting a will, saying, well, no, they had another will, or no, there's another one over here. Aretha Franklin, remember there was a situation with that. There were various versions of the will, and they had to go to court to determine which one would prevail. So here, let's see, this is just here's the discussion about the pour over will that I already discussed. All right. Oops. All right, let's see. Went the wrong way. The trust. Okay. And after I discuss the trust, we're going to talk about trust versus a will and how to make that call. So a trust is another legal document. It is an agreement where the grantor, the person creating the trust, designates a fiduciary or a trustee to manage the assets. And the body of the trust gives instructions on how the grantor wants their assets managed. Now, a revocable living trust, most people serve as their own trustee during their lifetime. I'll use the example of my father. He did not have a lot of cash at all, but what he did have was real estate. And so in his case, it made sense to create a trust versus a will because he had various types of assets. He had 4 homes, and he had a plan on what he wanted to happen upon his transition. He had 4 properties. He left instructions that upon his death, one of the houses was to be sold, and the sales proceeds were to be used to pay off the remaining mortgage on another one of the properties. 2 of the properties, he left each one of my siblings rights, life estate rights. They could stay in those houses for the remainder of their lives. But during that time, he required that they would have to pay all the bills in the house and to maintain the property. And as the trustee, he left me with the ability to take away their life estate right if they weren't living up to their expectations of paying the bills for the home and keeping it in good shape. And unfortunately, I have had to remove one of my sisters from her home because it just was a bad situation. But even with that, because of the trust was in place, it's not me. I'm following the instructions that my father left. So the trust can also be used. Suppose you have real estate in different jurisdictions. You're a resident in Maryland, you own a home in Maryland, but you also own a summer home in Florida. That would probably be a good scenario to put all of your real estate into a trust. Because if you own your home as an individual in Florida, now upon your transition, someone's going to have to qualify in that locality in Florida and probate your estate to handle that piece of real estate. So in that type of situation, for example, a trust would make sense. There are times where you can have a will that creates a trust upon your death. A testamentary will trust. It's not one size fits all. It really goes back to the first steps when you consider and decide how you want your assets to transition to the next generation. And what I tell folks is we first need to know what your goals are, and then we kind of reverse engineer in terms of determining which legal document will get you there. If a trust will get you there, a trust is typically less expensive than a trust. And sometimes a will is all you need. But if there are a lot of moving parts, the trust is going to be the better choice. You also have to remember, though, you can control but so much from the grave. But your trust and the will are the best things you can use to try to control as much as you can. Okay. Power of attorney. We talked a little bit about this before. The power of attorney, we probably all need to have one because, the situation with my father, once he was in a coma, now he doesn't have the wherewithal to designate an agent for him. He doesn't have the wherewithal to consider what it is he's trying to do. With a power of attorney, you have to be at least 18 years old. You have to be competent. You have to understand the breadth of what you're doing and the authority that you're giving someone to manage your assets. So you want to be very careful about who you choose as a power of attorney. We typically will advise folks to choose also a backup person as a power of attorney, but not to have because that can, get into situations where if two people are not in agreement, or if one is not available, one's on travel. So typically we will say designate one and then a backup agent. There are also special powers of attorney. When I was in the midst of divorcing my husband, we were selling our marital home. He was not available for closing. So he designated me as his special power of attorney only for the purpose of conducting that real estate transaction. So there are special circumstances where you may have a power of attorney that's for a particular purpose. And I already talked about some of this, a durable power of attorney. That just means that if the person becomes incapacitated, the durable power of attorney is still intact and can be used. Power of attorney in the health arena, we will discuss next. I did want to also mention the power of attorney doesn't limit the authority of the principal, the person who's designating their agent. Power of attorney only is to be used when, and I see the typo, my apologies in the title there, but it's only to be used when the principal is unavailable or incapacitated. And we talked about this already, the requirements being 18, competent. This is very important, and I want to stress for our children, our adult children who are not married. We all need to have one on our adult kids who are not married. Power of attorney ends upon death. I just spoke with a client last week that thought that her power of attorney would still, her niece would still be able to use it upon her death. And that's just not so. The power of attorney ends when the agent is aware that the principal has passed away. And once a power of attorney has expired, now you go into the trust, or the will becomes the controlling document. Advanced medical directive. Advanced medical directive is comparable to your financial power of attorney. The medical power of attorney is just when you can't speak for yourself, you have designated who speaks for you. If you don't, there are laws on the books who say who speaks for you. And just with the context of wills and transferring assets, you don't want the state, you don't want the District of Columbia to tell you who speaks for you. So you want to have something like that in place. Okay. So before we go on to how life insurance and estate planning go together, were there any questions? And I know at first I said we'd save them for the end, but I think this may be a good place to stop if there are any questions with regard to wills or trusts, general questions.
It's not a
I had
question,
a-
it's just something, you said that you should have power of attorneys on your unmarried adult kids.
Yes. Yes. For example, and I say that because they're adults. If something happens to them, they don't have a spouse to handle financial or medical issues for them. So you probably want to have a financial and a medical power of attorney, so that you can handle financial matters for them. Let's just say it's not incapacitated. Let's just say they're abroad for 6 months. You want to have something in place. If you go in and try to into their bank and try to do some banking for them, the bank will want to see some type of documentation. You have some business at DMV you want to handle on their behalf, they will want to see some type of documentation
Okay, thank you.
that you're authorized to act on their behalf.
Okay, thank you.
Mhm.
Michelle Robertson.
Yes, you mentioned you was gonna speak on the difference between the trust and the will.
Yes. Okay. So some of the differences between the trust and the will. When a will is probated or put on record with the court, now your will is a public record, and everyone sees who are your beneficiaries, what you left them. And sometimes that's that putting a will, probating a will, putting it on record with the estate may be necessary, for example, to indicate that there's been a transition of ownership in a piece of real estate, for example. And we also have heard many times that, folks contest wills all day long. Now, what you are starting to see now are no contest provisions in the will, which basically says if anyone tries to contest this will, they're out, they get nothing. So a will is a public document. A trust, on the other hand, is private. And you don't typically hear of someone challenging a trust. So sometimes folks will opt for a trust because they are private. They don't want their will having to go in public record anywhere. So those are a couple of differences. Another one is typically it just costs more to have a trust drafted than a will. There's more that goes into trust planning than a will. So it takes more expertise. And so typically you will have a will, a less expensive option. But even saying that, sometimes a will work for you. It just depends on what type of assets you have, how much. Now, what we would tell folks is if you have assets in the realm of $10 million and more, then that is going to be a trust. That's going to be a trust situation, and you will need to go to an attorney who specializes in those high estate planning scenarios. But the main differences between a trust and a will Typically, if it has to be probated, it's going to be public record. Your trust is going to be private.
Chat, it says, I'm my mother's only child. She is divorced and lives in DC. Is it still important for her to set up a will and a durable power of attorney?
Power of attorney for sure, because she's divorced. If something, God forbid, if she were to become incapacitated, even temporarily, and something had to be done, you could not walk into a bank and handle, affairs for her. If something, had to be handled with Social Security Administration, you would not be able to handle any of her affairs without having some type of document in place authorizing you to do so. So for sure, you would want to do that. A simple will, I would rather have a simple will than just say, well, I'm the only child, and we'll leave it at that, because I don't know if you've heard of the saying, people act strange around funerals and weddings. You don't know who may pop up, so I would suggest putting something in place, having some type of document in place so that there are no questions. And it's having a peace of mind. And for example, there may be some things that, perhaps your mom may want to leave a set of dishes to a friend of hers, or, something to that effect. Now, she doesn't have to necessarily have a will for that, but she may want to have a list of items that she may want to designate to different people. But I would still suggest having something in place.
I'm gonna take one more question from the chat. How does this work with businesses, LLCs? Can you specify how you want your business handled after your death? Or is it up to the beneficiary to decide what to do with your business?
Well, great question. It depends on if you trust the fiduciary to make decisions that would coincide with what you would want. I would suggest, if you already have an idea of what you want in terms of your business, you may want to consider let's see. I would probably say that would be more of a trust issue, and you could leave instructions in the trust who you want to designate as the managing member. Maybe there's someone in the business that's been working closely with you that you would want to give the option to purchase the business. But you can make those kinds of lay out those kinds of instructions in the context of a trust. That would probably be the best. That would probably be the best way to go for business considerations.
And
But
one
I have
final
seen trusted do that. I'm sorry.
There's one final question from Michelle Robertson.
Going back to power of attorney, how do you
Yes.
set up a power attorney? Where is it held? Do you hold it, or do you give it to the person that you're empowering? Is it filed with some legal entity to even create the power of attorney?
Okay, good question. So the power of attorney is it's a legal document that you would sign, and it would be up to you if you may want to have one or two originals that you would hold. And before you designate an agent, you definitely want to have that conversation with that person and say, hey, look, I am considering identifying you as my financial agent, power of attorney, in case I'm incapacitated or I'm unavailable. Make sure that person is in agreement with it. And I would suggest giving them a copy as needed, or at least letting them know, hey, if something happens to me, this is where you can find, and that's probably the better thing to do. If something happens to me, this is where you can get a copy of my power of attorney. But definitely hold on to the original yourself. We had a situation here where it was an elderly woman and there was an issue with her property, and she had to sign, they wanted her to sign a deed. Well, by the time it came up, she was having competency issues, and the family said, no worries, we have a power of attorney for her. Well, guess what? They could not find the original. So they had to go to court and basically take it through the court action. Whereas if they had been able to put their hands on that original power of attorney, it would have eliminated the need to have to file anything in court. So you would hold on to the original.
Thank you. Michelle Dawson.
Good morning. I had
morning.
one question about the power of attorney.
Sure.
Is it possible to designate two people as a power of attorney for maybe different things? I'm just thinking of my two sons. I'm divorced from their father, and I don't know if they would want to choose one over the other. So can they make both of us powers of attorney regarding, their health, their businesses, and things like that?
Yes, I have done a power of attorney for a mom who has two daughters that she's very confident that they will be able to work well together as her co-agents. And so if you wanted to designate your sons as co-agents, yes, you can do that. And I think you also said that you may want one son to handle one set of things, and maybe the other son, it would be better suited for this. You can specify exactly how you want it in a power of attorney. Yes, you can do that.
Okay, thank you.
You have to, every family is different though. That wouldn't work so well with my family, unfortunately, but
I
you have to know your
understand.
kids.
Yes, I'm sorry, but thank you.
You're
So
welcome.
Tony, before we move on to life insurance, there's a couple of questions in the chat that just probably need clarifying. So POAs, powers of attorney for adult kids, are you saying anyone over 18, or should it be when they're in college? Can you just clarify that?
Well, I would say if they're over 18 and, maybe they have a bank account or a savings account, or, some of our kids are influencers on social media, and they may have PayPal accounts or, that kind of thing. So I would say once they start accumulating assets, some of them may even have, my daughter, she has a girlfriend that sells lip gloss. She has a lip gloss line. My son has a friend who has a t-shirt line. So, whenever they start accumulating assets, whether it's traditional assets like a savings account, or like I said, they may have a little side hustle. Then you want to have a financial power of attorney in place. You want to have a medical power of attorney in place when they're 18. Because if something happens to them and they're unable to speak for themselves, in a medical situation, you want to be able to speak on their behalf.
Okay, and to respect the time and the rest of the presentation, we're going to stop questions and we're going to allow Tony to complete the next portion.
Okay, life insurance and estate planning. In my other life, I worked as an insurance agent and a financial representative for New York Life Insurance Company. And it was at that time that I learned a lot. There was a campaign at the time to place life insurance policies with Black families and businesses as a means of building generational wealth. And what I learned at the time is that there are other cultural groups siblings will come together and they will get these $1 million policies on the patriarch or the matriarch of the family. And then upon the transition, siblings, split the life insurance proceeds, which are largely tax-free. Now you have to put that in place before mom and dad or grandmom and granddad are failing, in their health. But we did learn that there are cultures who will do that, and that's That's how some of them have built generational wealth with these deposits of life insurance proceeds. So you may even use life insurance proceeds, for example, to fund an annuity. You know, the different things that you can use with those proceeds. So here, what I wanted to do was to talk about life insurance, and the basic question, the first question is, how much life insurance makes sense for you? You know, I had a greater need for life insurance when my children were minors and I had, you know, a mortgage coming in every day versus now where they're adults and they're out of college. I don't need as much life insurance coverage now. But I want to leave you with this acronym to help you determine what is your life insurance number, what makes sense for you. L, legacy and loans. Legacy. Do you want to insert or make a deposit of you know, this lump sum of money into a future generation? Is that something that's important to you? Do you want to leave something, a legacy, perhaps for a church, a scholarship program? So whatever that number is, you want to have that, you want to identify that number. L is also for loans. Suppose there's still a mortgage on your house. You may want to leave enough life insurance proceeds either to pay the mortgage off altogether, or enough life insurance proceeds that, okay, this is enough that you can pinch off 2 years worth of mortgage payments. And after 2 years, you need to make a decision. Either you're going to sell and relocate, or 2 years should give you enough time to replace whatever income that I was bringing in. So I'm going to give you either money to pay off the loans altogether, or just to give you enough money to pay for a certain amount of time. Okay. So you want to identify what is your legacy number, what is your loan number. The I, income. If something had happened to you yesterday, your income is gone from that household. Do you feel a need to replace your income for a certain period of time? Maybe you do and maybe you don't. For those of, you know, I'm divorced now. There's no need for me to replace income for anyone. That's not a number for me, but that may be, you know, someone who's married or someone who has minor children. That may be an important factor. So you determine, what is my replacement income number? I may want to just replace my income for a year. I may want to replace it for 5 years. The F is for final expenses. And beyond final expenses, you know, perhaps you have a significant amount of family members on the West Coast, you know, children or what have you. Do you want to provide any funds for maybe folks coming in town? Do you want to provide money for that spouse who may not want to work for a couple of weeks or a month, grieving or what have you? So whatever that final expense number that you think may work for you. Typically, when I was working for New York Life, most people would call that number like $25,000, but that is totally up to you. E is for education. If something were to happen to a mom who has school-age children, you know, does she want to designate part of life insurance proceeds to help fund for future education? For me, I don't have the education cost anymore, the consideration, because both of my kids are out of college. I don't have the income. Really, for me, the only thing is legacy and final expenses. But that's different for everyone. So consider, what is your life insurance number? Your loan, your legacy, income replacement, final expenses, and education. Okay, this is a little different. I typically don't do this, but I thought that this would be good for business owners, because a lot of times in estate planning, folks just don't think about this. And I probably think about it because I used to work for the Patent and Trademark Office. So I just always have an eye for intellectual property. So intellectual property considerations for the business owner. First, what is intellectual property? We've all heard of trademarks and patents. You may have a copyright. Maybe you've written a book. Maybe you've painted a picture. Dr. Paz, I think your father is an artist. Maybe you've written poems. All of that is intellectual property. Even your brand. You may have a brand on social media. You have a podcast. You have a blog. All of that, you're known by your name. That is intellectual property. Intellectual property we can think of as like a bundle of rights. All right, I kind of went through this before, but you have your copyrights for plays, song lyrics, trademark. Trademark is how you assemble a word, a sound, a color that you can identify a product or a service. Patents go for things that are inventions. Trade secrets. Who has the recipe to Kentucky Fried Chicken or Coca-Cola? It's a trade secret. They're not gonna file that with the Copyright Office. They don't want you to know how they make it. And then this is the best picture I could find for this. But the last one is for unauthorized use of your name or your image. Okay, copyright protection, original works of art. Again, you may have jewelry that you've designed or choreography, anything. These are also part of your assets to consider what's going to happen once I transition. You want to know what is going to happen with my intellectual property. Trademarks. You all could probably identify each one of these, the company, you don't even need any words, but every single one of these you could identify. And trademark can be on the federal realm. You see the R with the circle around it. That means it's registered with the Patent and Trademark Office. The TM designation is what we call the common law designation of a trademark. So if any of you out there are out on social media and you have a name you go by, Dr. Paz, we've had this conversation. You want to slap a trademark up there, symbol up there to indicate to the public that this is not a little cute name or cute picture, but this is my trademark. So back off and don't use it. All right. Patents are just for things, inventions. I had a lady from my former church. She was a nurse and she actually invented a surgical instrument. She said she noticed in a lot of surgeries that had to do with the uterus, there was a lot of unnecessary bleeding, and she actually invented a surgical tool. Let's see. Trade secrets. I had a member from, I used to attend Greater Mount Calvary Holy Church in Washington, D.C., and one of the members had this flavored tea, and she wanted to send the recipe to the Copyright Office. And I said, no. You don't want to put that on public record. You want to keep that a secret. It could be for the business owners, it could be your client list. It could be computer code. I mean, all these things in the business context, all these things are your intellectual property, and there's value to that. The right of publicity, and again, now I have a Virginia code. Maryland and DC do not have statutes on the book, but they do recognize under common law right of publicity for unauthorized use of your name or picture. Now, this is, for example, you're on social media and you have a brand that's out there. You want to protect that. So what are, in the terms of intellectual property and estate planning considerations? Well, first of all, do you own any intellectual property? And sometimes people think, well, yeah, I own that trademark. Well, you want to confirm that you actually own it. Is it registered somewhere? Are you using it? Trademark, for example, if you don't use it, you lose the ownership rights. If you do have intellectual property, have you authorized anyone under a license agreement to use it? Do you have royalties coming in? All these kind of things. Do you have contracts that impact your intellectual property ownership? Valuing IP can be tricky. And they have specialists out there. You may have, let's see, you may have, well, the Michael Jackson estate, for example, they have had to have experts go in and value his estate assets, but that can get a little tricky. All right, ladies, Well, I know we've been having kind of questions and comments going through. How are we doing on time? Oh, okay. Well, let me hush. Here's my contact information. I will tell you this, texting and email are the best modes of communication for me. And, you know, if there's some questions that we don't have opportunity to discuss today, I would be more than happy to have conversations offline.
Thank you, Tony. Are there any questions? This was great. It's got me thinking about several things, several
Great.
action items that I need to take once I get off of this call. And it's good to just think about visioning if you have businesses specifically. There are a lot of business owners on this call, and you just don't think about protecting your business after you're gone and making sure it's going to be a viable option as an asset to your heirs, to your children. So I think that's great to bring that topic up and make sure it's included. Did any other SOARs have any, or SOARs, or sorry, not just SOARs, but we have people from all over the community. Anybody have any questions? All right, Paz, I'm going to turn it over to you for final remarks.
All right. Well, as usual, Tony Russell delivers. She delivers. So we want to thank you so much for all, excuse me, what is is the acronym and breakdown again? I'm sorry, someone asked that in the chat before. What is the acronym and breakdown again?
So I think she was talking about
life.
Yeah.
The life.
Yes.
Life. L is for legacy and loans. I is for income replacement. F is for final expenses. And E is for education.
Thank you.
So
again, we thank you so much, Tony Russell, for all of the education, the enlightenment. I'm sure everyone has learned a great deal from this short period of time. We could have talked about this for another few days. So I put a link in the chat to the survey. So if everyone could please fill out the survey. It shouldn't take you any more than a minute. We hope that you all will move forward in your legacy planning or start if you haven't already. Again, we want to thank you on behalf of the Washington, D.C. alumni chapter of Delta Sigma Theta Sorority Incorporated. Thanks to our president, Nicole Jordan, our second VP, Erica Scavilla Hill, and I believe I saw our first VP, yes, Tamara Wells Lee. So we will have several events coming in the future. If you would like to get access to those, you can leave your information in the survey. And any questions can be directed to to Tony or the Financial Fortitude email address, which is, help me out, Terry, FinFortitude at, you're on mute.
Oh, I'm sorry. FinFortitude at WDCACDST.org. Fin, Fortitude at WDCACDST.org.
Yes. And if you have any ideas of seminars you'd like to see us present in the future, please send those over as well. So thank you for sharing your morning with us. I know everybody isn't in the DC area, and some of you are waking up early. Bless you. Our apologies for the interruption earlier. That was new for all of us, but with grace and patience, our presenter handled it beautifully. So thank you. Enjoy the rest of your Saturday. We love you. and we want you to be financially free. Thank you.
Thank you.
I'm going to end the call.